else on these cases?
No, Mr. Examiner. Yeah.
All right. Ms. Vance?
Nothing from me.
Thanks. We're off the record in these three cases. Let's move on to Pride Energy 25312.
Good morning, Mr. Examiner, Counsel Sharon Shaheen, Spencer Fain on behalf of Pride Energy.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of EOG Resources.
Ms. Vance, did you object?
Yes, we did.
Okay. Thank you.
And good morning, Jackie McLean with Hardy McLean on behalf of Red River Energy Partners.
Did you say Red River?
Correct, Red River
Okay.
Energy Partners.
Did
And
you
we're
object?
just observing.
Oh, observing. Okay.
Good morning, Mr. Examiner. Carrie Hatley entering an appearance on behalf of COG Operating and ConocoPhillips Company, and we are objecting in this case.
Oh, you are? Okay. That's a new one. All right.
Mr. Examiner, Jim Bruce representing Kaiser Francis Oil Company.
Morning. Oh, what's your position, Mr. Bruce?
I'm here to see what EOG and ConocoPhillips are up to.
Okay.
As
But did you,
opposed,
so you just entered an appearance without an objection?
I think so, yes.
Let me take a look. Or Ms. Shaheen, do you know whether Mr. Bruce's client objected?
He did not, Mr. Examiner.
Oh, okay. Thank you, Ms. Hatley. Okay. All right, Ms. Shaheen, it's your case. How do you want to proceed?
I have conferred with Ms. Vance, and I understand that EOG will be, they've sent out well proposals and will be filing competing applications.
Okay.
So we talked about the possibility of having this set for another status conference, June, I think it's 26th.
Well, if they're if they're filing competing applications, why not just set it for a contested hearing?
Well, the parties are negotiating and do help
see.
to work it out. And so that would give us some time to get started on negotiations and hopefully work it out so that a contested hearing is not necessary.
25312. Let me see when your application was filed, Ms. Shaheen, or do you already know?
I do, March 31st.
Okay. Well, the March cases are getting stale on our docket. So we need to do something with it, and to kick it down the road for another month for another status conference to then set it for a hearing is just too long for the division. So what I'll do is I'm going to give you some dates to think about. And you can pick one now. If you want to have another status conference in June, we can do that as long as we have a contested hearing set.
Okay.
But I want to get one set and locked in place that the parties agree to. We have July 15, July 29, or August 12. What's your preference?
I believe our preference would be August 12th, just to get the parties enough time to get to an agreement a week before that date.
Okay. Ms. Vance?
Yes, I mean, just to echo what Ms. Shaheen said, our preference would be a status conference next month without setting a contested hearing. I would have to confer with my client before I committed to that date.
Okay. Well, if you can't commit to that date, then you can either have July 29 or July 15. But those are the three dates that I'm offering for this case to move forward, and your competing cases as well. How many cases are you planning on filing, Ms. Vance?
I have to review the well proposal to see how many applications we're filing, but I did just receive some feedback from EOG. Our preference would be for the August 12th.
Fine. And that is available. So we'll issue a pre-hearing order for August 12th. And we will also expect that you will file, Ms. Shaheen, a continuance to June 22nd for a status conference.
June 22nd or 26th?
Let me look. It's the 26th. Okay, Ms. Shaheen?
I understand I'll be filing a continuance for the Pride case. Obviously Ms. Vance's cases won't be ready for hearing by then, but yes, I will do that.
True, they won't be ready for that. When are you filing your cases, Ms. Vance?
We will be filing around June 12th, because they will be ripe by then.
Okay,
So we should be able to at least go to the status conference and consolidate all of the cases under an amended pre-hearing order.
perfect. Okay, well, we'll issue a pre-hearing order for Ms. Shaheen's case for August 12th contested hearing, and then we'll consolidate your cases when they're filed. Anything further, Ms. Shaheen?
Not from me. Thank you.
Ms. Vance?
Nothing from me.
Any other party?
No, sir.
Okay, we're
Yes.
off the record in that case. Let's move on to 3R operating. It looks like there are 4 cases, but I'm not sure that they're consolidated. So let's just call them in groups of 2, 25321, 25322.
Good morning, Dana Hardy with Hardy McLean on behalf of 3R Operating.
And Ms.
morning.
Hardy,
Sorry.
hold on, Ms. Vance. And Ms. Hardy, should we have consolidated all 4 or just 2 at a time?
I think just 2 at a time.
Perfect, thank you. Okay,
Good morning, everyone. Dina Bennett on behalf of Coterra Energy Operating. And we did file an objection to these cases,
to these 2 cases or more than 2 cases?
just these 2.
Just these 2. Okay, what's the objection based on, Ms. Bennett?
Coterra is sending out competing
Oh.
proposals
Okay.
and is going to be filing competing applications.
Okay, perfect. Thank you, Ms. Bennett.
Good morning, Michael Rodriguez with Civitas Permanent Operating, enter an appearance in 25322 and 21.
And your position?
As of now, we've just entered an appearance, but like Cimarex, if differences aren't resolved, I believe Civitas may file competing applications as well.
All right, Mr. Rodriguez, I understand that position, but you would have to do so in a timely fashion if you want them to be heard in a contested hearing.
Sure, and proposals have been sent out,
Okay.
so we meet the time requirements for
Okay.
that. I think whatever the hearing date is, we should be able to accommodate filing the applications.
Okay, that's helpful. Thank you, Mr. Rodriguez. So Ms. Hardy, back to you.
And Mr. Examiner, I think at this point it does make sense to set these cases for a contested hearing. And we've consulted with 3R about dates and would prefer a date at the end of August if possible.
I think we have one available. Hold on. We have here August 26th.
That would be perfect.
Excellent. Ms. Bennett?
Thanks. I have also consulted with Coterra about potential dates, and I thought that it would be August 12th. So they were ready to, they're agreeable to August 12th. I haven't checked with them about August 26th, but I will do that.
Well, let's ask Ms. Hardy. I know August 26th is preferable, Ms. Hardy, but would you be available for August 12th?
My witnesses do have conflicts with the August 12th date.
Okay, all right. Okay, so Ms. Bennett, we'll wait to hear from you, but we'll issue a pre-hearing order for August 26th. And Mr. Rodriguez, August 26th?
That sounds great.
All right, sounds good. Okay. Anything further on these cases?
No, thank you.
Oh, thank you.
So Ms. Hardy, before I go off the record in these cases, do you want to continue them for another status conference before August 26th?
That's probably a good idea so that we
Okay.
could determine if negotiations have proceeded and if we still think we need the contested hearing.
Perfect. What about in July? What if we set these, or what if you continue them to the July 24 docket for a status conference?
That would be great. I think that's a good idea.
All right. And by then we'll have Ms. Bennett's cases so we can, and potentially Mr. Rodriguez's cases so we can consolidate them and have one status conference July 24. Okay, Ms. Bennett?
Yes, thank you. Just had to
Okay,
unmute.
Mr. Rodriguez?
That sounds good. Thank you.
All right. Now we're going to call the next group of 3R cases. They are 25323, 25324. Entries of appearance, please.
Dana Hardy with Hardy McLean on behalf of 3R Operating.
Okay, thank you. Ms. Hardy, before I go to the other parties, why are these not being consolidated with the other two?
Well, they're different. It's different acreage and different ownership interests and different parties objecting. So
Okay. All right.
that's the reason I was thinking.
That makes sense. I understand that. Okay.
Yeah.
Let me just make a note here before I take any more entries of appearance. Okay. Okay. Mr. Rodriguez?
Good morning, Michael Rodriguez on behalf of Civitas Permian Operating LLC, and we did file an objection in this case.
Okay. And what's your intention?
I'm sorry, in both cases. So there's been ongoing fruitful discussions to resolve the parties' differences, but at this point, it's just like the previous cases. If there isn't timely resolution of those problems, Civitas will file competing applications as well. And assuming we're on track with the previous two cases for an August hearing, we certainly would be able to accommodate that with filing applications.
Okay. Now, so Mr. Rodriguez, just out of curiosity, what is your ownership interest in this piece of land?
That's a good question. I don't know off the top of my head, but I can find out hopefully during these conversations.
Ms. Hardy, do you know what 3R's operating interest is in this, percentage in this land?
I don't off the top of my head. I can find that out, and I should have it in my records here, but it would take me a couple minutes to figure that out.
It's okay. I just was curious because, it's one of the factors that plays into the, who gets the order. And I just wondered, okay, I'll leave that question alone. Forget the question. We'll move on. So are there any other entries that I see Sharon Sahin's, but her monitor is not on, so I don't know what she's doing. Ms. Shaheen?
Yes, Mr. Examiner, I'm sorry. I wasn't listening. To be
Ms.
perfectly
Shaheen,
frank.
are you entering an appearance in 25323 and 24?
25323 and 24.
I believe Ms. Shaheen is entered for Flat Creek in 25323.
I think it might be.
My apologies. I'm trying to get back to the docket.
Oh, you're right, Michael. I can't see.
25324.
Four.
Oh, I'm not on this. I have a vague recollection that we had an interest in the 3R operating, and I can't recall which case we've entered an appearance in, but I'm happy to take a quick look.
I think everyone said that it's 25324, machine.
Okay. Oh, there it is right there. My apologies for missing that in my review of the docket.
So, Ms. Shaheen, have you objected?
I believe we did.
Okay, I'm seeing.
Let me double check. My apologies.
I think
Hardy,
Civitas is the
Ms.
only
Hardy, it's
object.
your case. I know Mr. Rodriguez seems to know what's going on, but Ms. Hardy, it's your case. Has she objected?
I do not believe so. No.
Oh, okay. Okay, good. So Ms. Shaheen, it looks like you're monitoring. Okay, I just was curious. Ms. Hardy, how do you want to proceed with these two cases?
I think we can handle these in the similar manner to the prior cases, even though they're not consolidated. I think a status conference on the July docket and a contested hearing on August 26th would give the parties time to try to work out an agreement and proceed if not.
Okay. We'll issue a pre-hearing order for August 26th. We'll have a status conference end of July on the 24th. And that gives you, Mr. Rodriguez, time to file competing applications if necessary. Anything further on these two cases?
No, thank you.
Not for me.
Wonderful. All right, thank you. We're off the record in those cases. Let's move on to number 34 and 35 on our dockets. That is 2533536 Admiral Permian. Entries of appearance, please.
Yes, Jackie McLean with Hardy McLean on behalf of Admiral Permian. And, Dan, I think Dana will do the other. Sorry.
And Mr. Examiner, Dana Hardy, also with Hardy McLean, representing COG operating and Concho Oil and Gas.
Very interesting. Is there a wall? Do I see a wall?
There is
between
literally
you?
a wall behind me.
All right.
But no, they have the same interests in this proceeding.
Well, that's interesting. Okay, thank you. So then, Ms. Hardy, you're so you're not objecting, obviously. You're just representing a different client. Okay.
Right, and COG supports these applications.
Okay, you said COG or EOG?
COG.
You said COG.
COG.
I see. So it's not EOG, it's COG that you're representing in this case. These cases.
Correct.
Okay. All right. Do we have any other entries that you know of?
Mr. Examiner, Jim Bruce representing MRC Permian Company. And MRC objecting.
You are objecting. Okay. And what's your intention, Mr. Bruce?
Within the next few days, MRC will send out counter proposals and intends on filing applications.
Okay, fine. That makes sense. Okay. Are there any other parties that you know of?
No.
Okay. So then this would just potentially be MRC versus Admiral COG.
Correct.
Okay, very good. How do you want to proceed, Ms. Hardy?
Well, I think that Admiral and COG would like to request a contested hearing date, and Ms.
July
McLean,
20. We're hoping to do July 29th because there is a federal lease expiration in September. And Admiral has already received all their BLM approved APDs for this spacing unit. So we want to move forward as quickly as possible.
I understand. So, Mr. Bruce?
Mr. Examiner, I would guess that I would probably be filing, since the proposals are still to go out, I wouldn't be filing until mid-July or mid to late July. So I would ask my other counsel, what is the expiration date of the lease?
I know that it is in September. I don't know the exact day in September of the lease, but this is just really seeming like delay tactics on behalf of MRC because Admiral sent out well proposal letters in February. They've had these for quite some time, and they've been aware of this since February. To file applications in July, 5 months later, is really going to adversely impact Admiral and COG's development plans for this area. So we would still request the July 29th hearing date.
Mr. Bruce?
Well, I said I would probably be filing for in June, not July. Other than that, I was just informed of this recently, but I think this is the first hearing set up for this matter, other than the one that I objected to. And if they had an expiring lease, well, I mean, that's not MRC's fault. I will ask my clients about July 29th date, but I would probably prefer an August.
So, Mr. Bruce, I'd like to explore something with you. Just give me 1 minute, though, to look up this Admiral Permian case in our system.
Okay.
And I want to talk to you about our 30-day policy in a case such as this. So 25335 was filed April 8th. So it's, about a month and a half old now. It's not that old. And it looks like they thought they were going to hearing by affidavit until the objection came in.
Yes.
I see that.
The objection was one day before the
I
docket.
see. I see it. Yeah, on the 6th day of May. So, Mr. Bruce, I have a question just to explore this with you. Now, I know that the division has a policy that 30 days after well proposals are sent out, a case may be filed with the division. And I believe the purpose of that, and this is where I need your help, Mr. Bruce, because you've been here a heck of a lot longer than I have. I thought that
I don't know whether to thank you for that or not, but
I think the purpose of that 30-day period to wait to file is to allow the parties to negotiate. Would you agree with that?
oh, sure, Mr. Examiner. I absolutely.
Okay, so you agree with that. And Ms. Hardy or Ms. McLean, do you see that 30-day period having a different purpose?
No.
Well,
Ms.
Mr. Examiner, I think the 30-day proposal period is to allow the parties time to negotiate.
Mhm.
I think the 30-day application filing
It's for
deadline
notice.
For
Right.
notice.
is for notice, right?
Yeah, that's not what I was asking about.
Okay,
But
yes.
I understand the difference between them. Thank you. I was talking about the idea of waiting, once proposals are sent out, waiting another 30 days before filing the initial application. So the reason I asked this question, Mr. Bruce, is because in this case, since the parties have been negotiating already since February or something of that nature, according to Ms. McLean, and I don't know, if that's correct or not from your perspective, but it seems like you wouldn't need to wait the full 30 days to file a competing application in this case. Would you say that that's not correct, or is that okay?
Mr. Examiner, actually, that's always been my position, but a lot of the other attorneys have objected when I've raised that issue.
It's interesting.
So,
Okay.
so I will get together with my clients.
Okay.
I don't have a proposal letter yet, so I can't draft the applications.
Okay.
But I'm certainly and personally in favor of, if there is an existing case, shortening the period from sending out the proposal letter to filing an application.
Okay. And Ms. McLean and Ms. Hardy, do you agree with that position?
Yes, I think that's fine for these cases. Because if he were to file by June 10th for the July, what would be the July
Mhm.
10th docket, that
Right.
would give us plenty of time
Mhm.
to notice and everything.
Right. Agreed. I think everyone's on the same page here. Ms. Hardy,
Yes, I agree.
you agree as well. Okay. So, Mr. Bruce, please file your competing application by June 10 so that we can get these to a hearing on July 29. If your client is unavailable July 29, please file a motion.
Yes, sir.
All right, then we'll issue a pre-hearing order in these two cases to be consolidated or amended down the road when Mr. Bruce files his competing applications for a contested hearing on July 29.
Thank
Anything
you.
further from you, Ms. Hardy?
No, thank you.
Ms. McLean?
Nothing. Thank you.
Mr. Bruce?
No, sir.
All right, thank you, everyone. We're off the record in those two cases. We're going to move on to Avant Operating 25347, 25348. Entries, please.
Good morning, Mr. Hearing Examiner. Yaritza Pena with Module Sperling on behalf of Avant Operating 2 LLC.
Thank you.
Good morning,
Morning,
Michael
sir.
Rodriguez with Civitas Permanent Operating LLC, and we did object to these two cases.
Perfect. And before we go to any more entries of appearance, it's very helpful when you make your entry of appearance to tell me if you've objected or if you're just monitoring. And in your case, Mr. Rodriguez, are you planning on competing applications?
It's a possibility. There's a lot of
Okay.
nuances to these applications.
Okay.
So I think depending on negotiations, which we're kind of in a negotiation triangle with Paloma as well, I think it just depends on the outcome of those negotiations.
So nothing immediate in mind.
Not yet, no.
Okay. All right. That's all I need to know. Who else?
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production Company. And we entered in appearance and objection.
Okay. Your intention coming up is what?
Currently, we're just objecting.
Okay.
I'm not aware of anything beyond that.
Okay, so you're just negotiating using your objection. Okay, I understand. Thank you.
Hey, good morning, Mr. Hearing Examiner. Michael Jewell, Jemison Natural Resources Law. On behalf of Paloma Permian Asset Co., we are objecting in both cases. Currently negotiating with both Civitas and Avant, but prepared to file our own competing applications shortly after Memorial Day if need be.
Okay, perfect. Thank you, Mr. Jewell.
And good morning, Jackie McLean with Hardy McLean on behalf of Permian Resources. And we're just observing.
Thank you. All right, so Ms. Pena, how do you want to proceed?
So as the parties have mentioned, we are all in negotiations, but Avant would like to move forward with scheduling a contested hearing. And we had discussed a date, and July 15th would work for Avant.
Okay, fine. So that's fine with me. So Mr. Jewell, you had mentioned filing competing applications, and I wanted to. Were you listening when we talked about the 30-day policy of the division to allow parties to negotiate?
Correct. Yes, sir. And we have sent JOAs to Avant and to Civitas as well, so that is well underway.
And I guess what I'm trying to telegraph to the parties is that when we have ongoing negotiations already, and we know that and an application has been filed with according to that policy with the 30 days. So there's been plenty of time to negotiate. I'm willing to shorten that 30-day period to be able to set a contested hearing and get those competing applications filed before waiting yet another 30 days. So I just wanted to make that very clear. So you said you were going to probably file sometime after Memorial Day.
In June, yes, sir.
If you could file by June 10, that'll allow us to notice on the early July docket, which would allow us to go to hearing on July. I'm sorry, what day did you say, Ms. Pena?
The 15th?
15th. So that'll allow us to get to a July 15 contested hearing.
Understood.
Yeah. So your cases would appear on our notice for July the 10th, but then we would administratively move them to the July 15th contested hearing date. Okay?
Yes, sir. Thank you.
Mr. Jewell, when you file your competing cases, would you file a motion to consolidate them with the pre-hearing order that we're going to issue for Ms. Pena's cases?
That does make sense. Yes, sir. We'll do.
All right. Thank you. Ms. Pena, anything further?
Nothing further from Avant.
Mr. Hearing Examiner,
Rodriguez?
I'd like to add a little context here. So
Sure, please.
Civitas was not noticed until these cases were set for May 8th originally. We
Okay.
received notice via email on the 1st. And so we objected initially because that was well short of the 20-day notice requirement.
Right.
But on top of that, we requested a JOA around that time. We didn't receive a JOA until maybe, I think, a week or two ago. So there's been very little negotiations, at least
Right.
with Avant. in Civitas, and I think Civitas' position is that this is still rather premature to be moving forward so quickly. There's no, as far as Civitas understands, there's no reason to force these to a contested hearing just yet when we could reset maybe next month for another status conference. And then at that point, we can understand what where the positions have evolved to and have more firm positions before setting a contested hearing. At this point, I think negotiations seem productive, and one or both parties may end up no longer opposing the Avant cases. And this could be a totally different hearing here or scenario here in a month's time. So I think, there's other hearing dates that you've suggested throughout the status conferences, the 29th and the 12th. I think if we did set a contested hearing date, allowing the parties a little bit more time to position themselves would be beneficial. And so I think Civitas would be requesting at least maybe August 12th, if not that, then July 29th. And having a status conference in between the today and the contested hearing.
Thank you, Mr. Rodriguez. Give me a minute to look at a few things, and then I'm going to come back to you, Ms. Pena. Okay, so let's see. This case was filed April 11. Avant cases were filed April 11. Ms. Pena, did proposals go out a month before?
Yes, they did. And
how is it Mr. Rodriguez didn't get notice by email until May 1st?
So as we were preparing for the hearing, we were going through our notice and we realized that, they had been left off of our notice. So we sent them notice at that time. We also sent them a letter of the hearing, and these cases got objected to at that point. So that pushed the hearing out. And just to give a little bit more information,
okay.
If Mr. Rodriguez thinks that a status conference would be useful, we would be okay with having another status conference. This is the first status conference we've had in this case, but we would still prefer to set a contested hearing. So if August 12th works for everybody, we would also push for a contested hearing on August 12th.
So is it your preference? So of the three dates that I was giving out earlier, the July 15, July 29, and August 12th, are you saying your preference is now for August 12th?
Well, our preference would be for July 15th still. Avant does have the majority working interest in this acreage. So Avant has been negotiating with all the parties, but if Mr. Rodriguez is preferring a status conference, maybe a status conference between now and July 15th for a contested hearing still occurring on July 15th.
Okay, all right. So Mr. Rodriguez, you objected because you're hoping to enter into a JOA and not be forced pooled. Is that right?
Well, so there's a lot of nuances here. Like I mentioned earlier, there's a potash issue as well that affects. So the Thai curry wells are in potash, and one of the issues that we're having with Avant here is that there's one drill island to access a lot of the acreage surrounding the Thai curry, and part of that acreage is Civitas's Queenie development that it intends to develop shortly. Those are the competing applications. They don't directly compete, but we would be filing those that would, I guess, they would compete. They just don't overlap. But in that, we're trying to secure our place on that drill island. The BLM has recommended that both of the parties revisit the locations to determine the best way to utilize that drill island and to essentially re-on-site. So there's just a lot of, we can't move forward until we have an understanding of how to use that drill island. And I think that still these negotiations can help inform how we proceed at hearing. And again, Civitas just believes it's too premature to move forward at this time, given all the unknown variables.
So today is May 22nd, and I assume you've been aware of these cases at least since May 1st. All right.
Right.
So if we went to hearing on July 15, that would be, oh gosh, that would be 10, 11 weeks worth of time to negotiate a deal before the hearing. Are you saying that's insufficient time?
Well, it's 8 weeks, I believe, roughly 8 weeks, and we have Memorial Weekend coming up. So I'm just gonna say it's more like, I don't know, 7.5. I think that I I think that there's a lot of complexities here that it would be there could be a scenario where negotiations resolve some of the issues here to where one or both of the parties here could move forward unopposed. And setting a status conference could help just navigate where the a contested hearing may go, or resolve that and then move that status conference into a hearing by affidavit.
I'm confused by something you said, Mr. Rodriguez.
Okay.
If you were the only objecting party, then I would understand what you said. But we have Mr. Jewell who's filing competing applications. And so if you resolve your issues, that doesn't resolve Mr. Jewell's issues, does it?
Mr. Hearings Examiner, if I may.
Yes.
And I was less aware of Civitas's notice issue, and he and I did confer, and we were okay with pushing for another status conference. I want to assure you that we knew that this was going for affidavit before our protest, so we are ready to file. But if
Okay.
things continue to go well as far as negotiations, we can push this for another status conference. We wanted to make sure we respect all parties with our timeliness.
Yes. So Mr. Jewell, I don't know how much you know about my procedure here, but I give the applicant the benefit of the doubt when I come to setting cases for contested hearings. In my mind, the applicant's counsel knows what demands are on the applicant time-wise, and I'm not involved in that. They also know how negotiations are going as well. So Ms. Pena, what if we pushed it out to the July 29 special hearing docket? Would that be okay with you?
I would have to check with Levant. I would just like to reiterate that we are ready for the July 15th contested hearing. And in the meantime, having a status conference in June would give the division, the parties coming back in and discussing how negotiations are ongoing.
Mm-hmm.
And at that point, if the July 15th hearing is no longer necessary, we can move that and there'd be sufficient time. And at that point, we could also discuss if Mr. Jewell has filed their competing applications, which would also be consolidated for the July 15th hearing. I would have to check with Avant on the July 29th hearing date.
All right. Okay. So I like that option. So we'll issue a pre-hearing order for July 15. We'll set, Ms. Pena, you'll move your cases to the June 26th docket for a status conference. By then, Mr. Jewell will have filed his applications and his motion to consolidate. We'll have those cases there. And then we can hear from you, Mr. Rodriguez, on June 26th, and you can let us know what's going on. And I wonder something, Ms. Pena, do you also have the option to remove Mr. Rodriguez's client from your compulsory pooling application if negotiations are going well? And are you able to do that?
If that's something that the parties agree to at that point, I mean, I think that happens regularly in the proceedings where parties are not pooled at a specific time and if they're close to negotiating, settling, but that would have to be an agreement between the parties as well.
Sure, that makes sense. I'm just asking if that's an option, and it sounds like it is. Okay. Is there anything else, Ms. Pena, on this case?
Nothing else. We will move our cases to the June 26th docket.
Very good. And we'll issue a pre-hearing order today for the July 15 docket for a contested hearing. Anything further, Mr. Rodriguez?
No, thank you.
Thank you. Ms. Vance?
Nothing.
All right. Mr. Jewell?
No, sir.
All right. And Ms. McLean, you're just monitoring.
Correct.
Sounds good. We're off the record in these Avant cases. Thank you.
Thank you.
We're moving now to Rockwood Energy cases 25241, 42, 43, 44, 45, and 46. Entries, please.
Good morning, Mr. Hearing Examiner. Caitlin Luck for the applicant, Rockwood Energy LP.
Thank you.
Good morning, Mr. Examiner. Dina Bennett on behalf of Coterra Energy Operating, and we did file an objection to these cases. And our intent at this precise moment is to send out competing proposals, but I would like to give some more context on that before I commit to it.
Sounds good. Why don't you go on? Because I think that you're the only other party in this case. And before I go back to Ms. Luck, why don't you finish what you were saying?
Thank you. So these cases were actually set for a final status conference today. And with the idea that we were going to be setting a contested hearing date. And as you may recall, so these cases we've had one other status conference for these cases, which was back in April. And at that time, I had explained that Coterra was under the impression that Rockwood and Mewborn were working out an agreement that would perhaps eliminate the need for Rockwood's cases to move forward. On Tuesday of this week, Coterra learned that Rockwood and Mewborn were not moving forward with that agreement.
Okay.
And so it's only become recently very clear to them that, if Rockwood isn't going to dismiss its cases, that we will need to move forward. But that happened on Tuesday. On Wednesday, Coterra reached out to Rockwood and requested to begin discussions with Rockwood. And so I also wanted to just mention that Coterra has, I think, over 64% working interest in this acreage.
Okay.
And Rockwood, it's my understanding, doesn't operate any wells in New Mexico. They're only a non-operator at this point.
Okay.
I understand this might be their first foray into operating, but at this point, Coterra's position is, while these cases were set for a final status conference today, that's premature given the factual background, the context that brings us here today. And so Coterra's strong preference would be to set these cases for another status conference to allow Coterra and Rockwood to have communications, figure out if a contested hearing is really even necessary before we take much more time of the divisions.
Ms. Luck?
Thank you. So these cases were filed back in February. Rockwood's well proposals went out in February, so they have been on the docket for quite some time. And even though I only took over last month from Mr. Savage, I believe that Rockwood is ready to proceed to hearing on these pooling applications. They are an operator in good standing before the division, and even though it might be their first wells in New Mexico, they're ready to operate.
Okay.
I think at the last status conference, the division offered the July 15th and the August 12th contested hearings, and so Rockwood's prepared for the July 15th hearing date. Ms. Bennett has indicated that date doesn't work for her, but we would ask for a pre-hearing order today to go forward on a contested hearing because Coterra has had sufficient time to send out well proposal letters and to file competing pooling applications, and Coterra hasn't done so. There's been several months that have passed, and I checked the June docket because I thought that the applications might be filed as of this status conference, but that didn't happen. And so again, I think that where we're at today is that this is a little bit of a delay tactic, and these cases have been on file for a while. And I think that the July 15th docket's preferable, but if that one's not available, then August 12th would be the second available for me.
So, Ms. Bennett, I see that you filed an objection on April 2nd.
Yes.
Okay. And at that time, when you filed the objection, what did you think you were going to do?
Well, just backing up, the application was filed in February, but on February 28th. So the first
Right.
time the cases were even set for hearing was in April. So it isn't like
That's
they've
right.
been waiting since February to be heard. But on April 2nd, when I filed the objection, that was to protect Coterra's rights in the event that the Rockwood cases did move forward.
Mhm.
As I mentioned, it was Coterra's understanding that Rockwood and Mewborn were entering into an agreement, which would have meant, at least in Coterra's view, that the Rockwood applications would be dismissed.
So hold on, Ms. Bennett, hold on one second, because I want to make sure I understand what you're saying. When you say that Rockwood and Mewborn were entering into an agreement, how would that affect Coterra?
If Rockwood had divested itself of its interests in this acreage, then Rockwood would have dismissed its cases.
That's what you mean. So you thought that Rockwood would come to some agreement with Mewborn giving up its interest in this acreage, and therefore you wouldn't have. Okay, now I understand where you're going. But that negotiation fell through, according to you, on Tuesday. Then on Wednesday, you reinitiated negotiations with Rockwood.
That's right.
Okay, very good.
And sorry, one quick clarifying remark. I don't know when the Mewborn Rockwood negotiations fell apart or didn't mature. I only know that Coterra only found out about that on Tuesday.
I understand perfectly, and
Okay.
I'm not asking anything other. Now, at this point, what does your client hope to negotiate to drop its objection?
Coterra would like to negotiate with Rockwood so that Rockwood will dismiss its cases. And then Coterra could move forward to develop this acreage in which it has a majority interest.
I see. So you would like them to drop their cases. So, okay. And then would you be filing a compulsory pooling application at that time?
Yes, these cases, so this acreage, it's my understanding that that Coterra intends to develop this acreage. It just wasn't on its schedule at the same time that it was on Rockwood's schedule. So it's not that Coterra doesn't intend to operate this acreage or develop it. It's just they've now had to accelerate timing due to Rockwood's applications, but they do intend to develop it. And sitting here right now, I can't say if we would need to come back for pooling or if they would have voluntary agreement from everyone, but it's their intent to develop.
May I respond?
Oh, yes, I'm going to come. Of course, I'm going to come back to you, but I want to understand Ms. Bennett's client's position as fully as I can. And Ms. Bennett, as you know, my practice is to give the applicant the benefit of the doubt when it comes to setting, which I just explained a few moments ago. So Ms. Luck, go ahead.
Well, there's 2 points I wanted to make. I think that Ms. Bennett mentioned that her client has approximately 65% ownership interest in these units, but it's actually variable between the cases. So it ranges between my client has a 30% ownership interest in some cases, all the way up to 45% ownership interest in one case. And so I do think that there is a close ownership ratio on some of these cases. That's my first point. And then the second point, the reason that Rockwood's applications need to proceed at this point in time is because Rockwood is dealing with lease expirations that are, the soonest one is July 31st of 26. And we do understand that Coterra's lease expirations are further out, but that is the reason why Rockwood has filed these applications and needs to go ahead and proceed at this point in time with getting a pooling order as soon as possible to have a drill rig on schedule within a year of that time period.
Okay. All right. I understand, Ms. Luck. I understand, Ms. Bennett, where you're coming from.
Can I make one clarifying point about the lease expirations? It's my understanding that Coterra does have similar lease expiration issues or a term assignment expiration issue. So they're equally motivated to drill this acreage to meet their expiration. It might be a month after Rockwood's. I don't have the exact date. I know it's summer or fall of 2026, but we are still a year out, and Cimarex does have Coterra does have a term assignment expiration. So there's motivated to maintain their term assignment as well. It's not as if this is one side only trying to maintain its leases. And I did just want to reiterate that I am not available on July 15th. I did inform Miss Luck of that. I'm not available, and we don't have a witness. Our landman is not available on July 15th either. So the earliest we could go is August 12th.
So you're not available on July 29 either?
No, I'm not. I'm out of the country.
Good. Lucky you. Okay, so Miss Luck, I certainly am willing to set a contested hearing for these, but if Ms. Bennett's not available on the 15th of July or the 29th of July, I don't have much option here. So I can set these for August 12th.
Yes, if we could have a pre-hearing order issued with that date.
Yeah, and maybe that'll help your negotiations as well, Ms. Bennett.
Yes, and if we could do what you've done for the prior cases, which is set a status conference
by all
for July 24th.
By all means. Do you want to wait that
helpful.
long? Well, they're Miss Luck's cases, first of all. So Miss Luck, if we set these for another status conference, would you rather have June or July?
Well, I mean, the July hearing is only about 2 weeks before the hearing. So, I mean, we could let you know at that point whether or not we would need the contested hearing. I think that would be fine.
Okay. So Miss Luck, they're your cases. Why don't you continue them to the July 24 docket?
I will do that.
Okay. And this gives you plenty of time, Ms. Bennett, to file competing proposals if necessary.
Yes.
And as I said earlier, I'm not going to require a party to wait 30 days after a proposal is sent out to file an application if we have ongoing objections and negotiations already.
Mr. Hearing Examiner, I understand that in the usual circumstance, but there are other working interest owners that are involved in many cases that are entitled to 30 days to review an application proposal before we go to hearing. It's not just to protect the parties who are involved in the hearing.
I see.
So, and then just one other quick clarifying point. Sometimes, for example, if there's not a 100% overlap, one party may not even receive the proposal letters. So I understand that we can make, what I would propose is that the division not make a blanket exception to the 30 days, and the rule itself, the order itself does say, except in exceptional circumstances, there shall be 30 days. And so I would ask the division to make it a exception, not a presumption, but continue with the exception that the parties can demonstrate when they come to the division.
Okay, that makes sense. I understand. That's helpful. Thank you, Ms. Bennett. You said that the rule talks about the 30-day period. Where is that?
I meant to say the order that created the good faith negotiation requirement.
Okay.
That
makes sense. Okay.
Yep. Thanks.
I understand. Thank you. Yeah, I got it. Okay. Very good. By the way, that order was issued by the division or the commission? I
believe it was ordered by, it was either, I can't recall. There were two orders. One clarified the second one, and I'm not sure if they were both division orders or if one was a commission order, but I'd be happy to send the order to you if that'd be helpful. I have it handy.
Would you please? Yeah, Thank you. I mean, I'm sure I can find it, but if you can send it to me, that would be helpful. Thank you. All right, Miss Luck, anything further?
Nothing further. Thank you.
All right, Miss Bennett?
Nothing further. Thank you.
Okay, very good. We're off the record in these two cases, or these multiple cases, actually. Let's move on now to number. Actually, let's take a 5-minute break before we begin with Mewbourne Oil cases 25234 and 25235. We're off the record for 5 minutes. Thank you. It is 10:34. We're back on the record with Mewbourne Oil cases 25234, 25235, excuse me. Entries of appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Mewbourne Oil Company.
Thank you.
Good morning, Michael Rodriguez on behalf of Civitas Permian Operating.
And your position?
We objected to these cases due to ongoing negotiations, and as soon as negotiations have wrapped up, we'll withdraw that objection.
Okay, thank you.
Good morning, Mr. Hearing Examiner Darren Savage with Abbott and Schill on behalf of on behalf of Devon Energy Production Company. And we did object to these, and these are involved in competing applications.
Now you say competing applications. Are those competing applications that have been filed?
That's correct. These are related to the previous
yes.
cases 22 and 23.
Very good. All right, very good. I understand. Thank you. And Ms. Hatley?
Good morning, Mr. Examiner. Carrie Hatley representing ConocoPhillips Company. Representing COG Operating and Concho Oil and Gas, and we are monitoring only.
Thank you. So, Mr. Savage, we discussed these in a way earlier. Is your competing applications are only for these two Mewbourne cases, or are they to all four Mewbourne cases?
All four Mewbourne cases.
All right, thank you. Ms. Hardy, how do you want to proceed?
Mr. Examiner, we would propose to handle these the same way as the prior applications that we discussed that are competing between Mewbourne and Devon, and would like to have a status conference on June 22nd, along with Devon's cases, so we can then select a contested hearing date.
Okay. And Ms. Hardy, it's June 26th is the status conference docket, according to my calendar.
Okay, then I've got the wrong date. June 26th sounds good.
All right, good. Okay, so let's see these cases. And Mr. Savage, I know you told me already, but I'm going to ask you again. Your competing cases were to be on the June docket, the 5th, and we're going to move them to the 26th. Is that right?
That's
That is
correct.
right.
When we made the applications, we asked for requested the June 5th, and then we would, with
Perfect.
the idea that we would move them. Yeah.
Okay, very good. Did I, Miss Hardy, I don't remember, these were a while ago. Did I offer some potential dates for the parties? I did. Okay.
You did.
All right, sounds good. So at that time, we will choose a contested hearing if necessary.
Yes, thank you.
Anything further?
Not from you, Byrne.
Mr. Savage?
No, sir. Thank you.
Mr.
No,
Rodriguez?
thank you.
All right.
No, sir.
Ms. Hatley, I saw you shake your head. Thank you.
No, thank you.
All right, thank you. All right, we are now at the end of our docket, but we're going to hear a group of Matador Production Company cases in a motion hearing. So I'm going to call items 46 through 51 on our docket. This is 252, 47, 48, 50, 52, 53, and 54. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Matador Production Company.
Good morning.
Good morning.
Mr. Examiner, Jim Bruce, entering a late appearance for Mewbourne Oil Company.
Thank you.
Mr. Hearing Examiner Darren Savage with Abbott and Schill, also entering a late appearance on behalf of Alpha Energy Partners 2 LLC.
Alpha. Mr. Bruce, did you object?
No, sir.
Okay.
We're just interested in the proceedings.
So you're monitoring, but I think Alpha is objecting, are you not?
That is correct.
What's your intention, Mr. Savage?
So I found out yesterday that Alpha had acquired leasehold interest in this, and they were looking closely at what to do with this leasehold interest.
Okay. All right. So for now, just objecting, no further plans for now.
Objecting, and we requested a status conference on 6/26 in our objection.
Okay, very good. Okay, and then do we have any other entries of appearance?
Mr. Examiner, I just want to clarify, is this cases 25247 through 25254?
It sure is, Mr. Samaniego.
Yes, sir. Jonathan Samaniego, representative of for American Energy Resources.
Perfect. Thank you, sir. And we're having a motion here. Excuse me. We're having a motion hearing today after we, Mr. Savage, is there anything further from you before we go to this motion hearing?
No, sir.
Very good. Okay, very good. You don't have to stay on, Mr. Savage.
Okay.
We'll see about, well, let me ask Ms. Vance right now. Ms. Vance, are you okay with, once the motion hearing is done, moving these cases to the June 26th docket for another status conference?
I think our preference is to set a contested hearing as
Okay.
soon as possible.
Okay. Okay. So Ms. Vance, what dates are you looking at?
I believe, did you have some July dates available?
We had the 15th and the 29th.
Can I just email my client
course.
and just pitch those to them?
Sure, of course. So Mr. Savage, you've heard that Ms. Vance would like to set a contested hearing in July and a status conference, I think, at the end of June. Your thoughts?
So Alpha acquired this interest, and I believe it's a substantial amount of interest. We're looking at competing applications as a possibility. We need some time to send out a well proposal on that. But, you know, as you pointed out, there may be some options for the time period on that. But then whatever that might be, then we would need to file an application.
Okay. So why don't we look at the 29th then to give you a little bit more time? So Ms. Vance, the July 29th is, I think, fair for Mr. Savage since he's just, you know, getting up to speed on these cases. So if that's okay with your client, that would be my preference, would be the 29th instead of the 15th.
Okay, I would just ask then that could we have another status conference to touch base in June then?
Sure. I mean, that's up to I'm open to your moving your cases to the June 26th docket for a status conference. By all means.
Okay.
And then you'll let me know what your client has to say about July 29th for a contested hearing?
Yes, I'm gonna email right now.
Of course. Let's deal with these motions that we have. We have basically two motions. Mr. Samaniego filed a motion. You filed a response. Mr. Samaniego filed a reply. That's the first motion. And then we have another motion that you filed, Ms. Vance, which we'll get to second. But first, we're going to deal with Mr. Samaniego's motion. Mr. Samaniego, I have reviewed your motion carefully. Basically, I believe what you're saying in your motion is that because MRC Permian has unclean hands because it has several wells that are not in compliance. I know that you say there are a certain number of wells. Ms. Vance says there are a different number of wells, but basically it's because they are out of compliance. You feel as though they don't have standing to request these applications, and they should be dismissed.
Yes, sir.
Okay. And then I got a response, and then I got a reply. But I think the better way to deal with this is to, and I didn't see this in your response, Ms. Vance, but I think the better way to deal with this is to start from a different angle. So, Mr. Samaniego, the Oil and Gas Act in New Mexico does not provide a private right of action. When I say private right of action, I'm going to compare it to, let's say, the Clean Air Act or the Clean Water Act, which gives citizens a private right of action to hold people accountable for wrongdoing in court. In the Oil and Gas Act, the only one that has a right of action when someone's out of compliance is the division. Now, you've made the division aware that MRC Permian is out of compliance with several of their wells. And I appreciate that. So thank you. But it doesn't give you the right to represent the division here at the administrative stage or in a court, from my reading of the Oil and Gas Act. So I understand your unclean hands argument, and I'm not sure how that applies to standing to file an application, but nevertheless, without having a private right of action, there's nothing in the Oil and Gas Act that gives a private citizen the right to enforce the Oil and Gas Act. Do you understand?
American is an operator, not a private citizen. We are here competing against Matador. We are operating in good faith. We have permits on those lands, American 1, 2, and 3 wells. And Matador is encroaching, and in doing so, they are in violation of state law. I just want to put on the record the majority of these wells that Matador has in violation are on state lands. State statutes are very, very clear. And because they're in violation on state land and the public health is at risk and endangerment to the environment because of these wells that have not been productive, wells that have been drilled and have been left behind, dry holes, whatever you call it, but they need to be cleaned up. And by not enforcing it and giving them more permits today, that's a violation of 1915-5-8 enforcement of statutes and rules, which the division is charged with.
Okay. Thank you for pointing that out. Is there anything else that you'd like to say?
I beg you, Mr. Examiner, to please do not give Matador more permits when they have messes that they need to clean up.
Okay.
And why Dean McClure and Jesse Tremaine hasn't addressed this is pretty concerning, but that's a whole different area.
Okay.
We'll stick with Matador today.
Let me address.
And for Matador to be trying to sway the division into getting more permits for development is a waste of Matador's resources. And the whole reason why the division fought legislation to get rules to enforce on operators. And the division clearly here is not enforcing the statutes on mega oil operaters.
Okay.
And it's shown here today.
Mr. Samaniego, Mr. Samaniego, I'm going to interrupt you now for a moment. Mr. Samaniego, I'm going to interrupt you. Mr. Samaniego, I'm going to interrupt you for a moment. Ms. Vance, I'll get to you in just a moment. Mr. Samaniego, I want you to understand something, that the Hearing Bureau is an independent part of the Oil Conservation Division. We do not interact with the other divisions here to maintain our neutrality and our independence to be able to hear cases. So I wanted you to understand that I can't go to Mr. Jesse Tremaine and say, Mr. Tremaine, please do this, please look into that. That's not my job here. My job is to be fair and impartial to all the parties so that I can hear cases and make judgments based on the facts and not based on other things outside the record. So I just wanted to make you aware of that. But I understand your position. And I see that the court reporter has her hand up. Go ahead, Ms. Court Reporter.
Thank you. I would just like to please state that everybody speak one at a time in order to keep a clean record.
And that makes sense. And Ms. Court Reporter, do you have Mr. Samaniengo's spelling of his name?
I do not, but I will message the hearing coordinator to see if I have that.
I can just ask him to state it on the record. Mr. Samaniengo, for the court reporter's benefit, would you please spell your name?
Yes, sir. JONATHANSAMANIEGO.
Thank you, Mr. Samaniego. So because of that, so Ms. Vance, I'm not gonna call on you right now for this because I've read your response. Is there something else you wanted to say beyond your response?
Yes.
Go ahead.
So I just wanted to point out that Mr. Samaniego's reply to, or his reply or response to a response, in it, he added additional arguments and provided a whole slew of exhibits that he just sent across about 10 or 15 minutes ago. As the moving party, he should have filed or made the basis for his claims in his motion to strike. So I would ask that his reply be stricken from the record along with all of these exhibits that he filed 10 minutes ago. Beyond that, I did want to echo, because I wanted to say that Mr. Samaniego has not been deputized by the division as an enforcement officer. And this is a compliance issue, and Matador is more than willing to have any kind of conversation with the division if it has concerns.
Okay, so Ms. Vance, because I'm making the basis of my ruling based on what I already outlined earlier, do you have any issue with that ruling?
I do not. It sounds like you're not going to be evaluating his reply. Again, I would just ask that it be stricken from the record.
Okay. Well, you know, this is an administrative record. He's a party to the case at this point. He's a party to the case, and I'm not going to strike anything from the record, but I am going to ask you to draft an order outlining what I already stated, that the Oil and Gas Act does not give an operator or individual a private right of action to enforce the division's regulatory rules, and submit that after you send it to Mr. Samaniego for his position, and I'll sign it. So, Mr. Samaniego, thank you for your motion and bringing it to our attention, but really you do not have the ability and the power to enforce the division's compliance rules and regulations. Now, let's go on to your motion, Ms. Vance, and I've read that carefully. And Mr. Samaniego, I do see your response, Mr. Samaniego. It was a little confusing to me because of the way you drafted this. It seems like maybe you copied and pasted parts of Mrs. Vance's motion into your response. Is that right?
How I put the response together is that doesn't relate to the case. I want to focus on my response and not how it was put together.
Well, I'm asking you because I was confused when reading it, is what I'm saying. So in other words,
just ask me, what are you confused about, so that way I can clarify.
Oh, of course. I'm going to give you an opportunity, Mr. Samaniego, because you didn't have a lot of time when the motion was filed.
Oh, no, I had like a 10-hour deadline. Of course, I'm used to this. You guys always do this to me, and Paula Vance is very good at those late filings. That's her tactic.
Mr. Samaniego, please. We're trying to conduct this in a rational and
I'm sorry. I've been filing these since 2 a.m. So please forgive me if I'm a little tired.
I will. Let me just. You can be helpful to your own position if you would just respond to what I ask you and to give me what I need because I'm trying to be fair. I'm trying to be fair to both parties. Okay. So I have a motion to strike.
The same questions you're asking her. Please, I want it to relate to the case.
Okay. So I'm starting now to hear the motion to strike, where Permian filed a motion to strike your entry of appearance and objection from the record. Okay. Now, based on the motion that she filed, I'm going to review it now. So basically, Ms. Vance is citing in paragraph 1 the rule that says how someone deserves to be a party to the case is if they are entitled to notice. Okay, and she cites the rules, which are helpful to me. She also mentions that she's not seeking to force pool American energy resources in her second paragraph. In her third paragraph, she's talking about that American AER claims a mineral interest in the west half of Section 27. It appears this interest is subject to ongoing litigation regarding the ownership of the minerals, and the trial court has apparently entered summary judgment that neither AER nor its representative owns an interest in the mineral estate within those lands. And I'm supposed to see Exhibit A, a summary judgment. So I go to Exhibit A, which is here, and I see a court case in which I believe you were involved in, Mr. Samaniego. Have you had a chance to review this Exhibit A, First Judicial District Court, Margaret Dowling versus you?
I am aware of it.
Okay, good. Did you participate in this case?
I hired an attorney, Jacob Candelaria, and I called him and emailed him about this short deadline to send me documentation, give you guys a call, email you. I mean, whatever it's going to take and the opposing counsel was aware that motions have been filed to go to Supreme Court.
That's not, okay, I understand. I read that. Hold on, Mr. Samaniego, that's not what I'm asking you. Mr. Samaniego, I'm asking you very specific questions, and you haven't given me an answer yet. The question specifically was, in this district court case, not in today's hearing, were you involved in this district court case? And I believe you said yes, you hired an attorney to represent your interest here.
Yes.
Okay, very good. Okay, good. Now, Ms. Vance, I don't understand something here. How is this case related to the compulsory pooling cases that you filed?
So our cases involve the acreage that Mr. Samaniego is claiming an interest in, which I outline, I believe, in my motion, which is the west half of, let me pull this up. Section 27, Township 22 South, Range 28 East. In the filing, and I'm not sure if it came across with actually uploading to the OCD's images page, but I did highlight that the summary judgment relates to that acreage. I want to make sure that I state on the record that Matador doesn't take a position in those cases or in those matters, is just aware that there was a summary judgment regarding this acreage that Mr. Samaniego is claiming an interest in that relate to Matador's pooling cases.
Okay, so here we have on page 3 of the summary judgment, it says, as used herein, the term property shall be defined as follows: the west half of Section 27, Township 22 South, Range 28 East, Eddy County, consisting of 100 acres of fee land and all mineral rights. And Ms. Vance, are you representing here today that the compulsory pooling cases that you have filed and that Mr. Samaniego has objected to are the west half of Section 27?
They involve that acreage.
And more?
Yes, correct.
Okay, and more, but at least it includes all of this west half.
Correct.
All right, so then let's see what we have here. We have plaintiff. Now, Ms. Vance, I'm not reading this entire document here. Where in this summary judgment does it either extinguish Mr. Semenyengo's mineral interest or find that he doesn't have one?
If you go to page 7, you can see that the court hereby declares and what their findings are. If you look at A, B, C, and D.
I see it. I see it. Okay. All right. I see it here. And then, and I do see that Jacob Candelaria is the attorney for the defendant. And then we have here Exhibit B. Now, what is Exhibit B?
Exhibit B is an oil and gas lease, which relates to these lands. Matador is the leasee of, or at least part, has a percentage of the working interest lease, or is the leasee under this oil and gas lease. So they have a right to drill. You see it says Union Oil Company up there. I did provide an affidavit following this particular exhibit in which landman Chris Carlton attests to the fact that he explains it right here in paragraph 4.
Let me get there. Hold on. I wanted to look at this lease here. So before I look at your affidavit, this lease here is saying, what is this lease telling me in your own words?
That the leasee of that lease has a right to drill. They have the right. Those rights to drill have been handed over to the parties who are who have signed on. So in this case,
I see. That's why the Dowling plaintiff matters here.
Yes, correct.
So you're saying then that, okay, so when is this case filed? This case was filed, this summary judgment was filed 7/12/24. And this lease here is from 1973. I see. Okay, now I'm understanding how these two things relate to each other. Now let me read the self-affirmed statement of Chris Carlton. And Mr. Semenyengo, I'm going to come back to you in a minute, but I want to understand the position and the evidence before me, because I don't believe you filed any evidence in your response to this, and I haven't gotten to that yet, but give me a minute to read this.
Mr. Examiner, there's exhibits that I sent for that one.
Oh, okay, great. Hold on a second. Let me finish reading this affidavit here, and then I'll look at your response and your evidence in just a moment.
Yes, sir.
Applications, familiar with status, test of the MRC owns a lessee working interest, post spacing units attached is oil and gas lease dated 73 between Dowling and lessors and as lessors and Union Oil Company as lessee, covering the west half of section 27, recorded at Eddy County, reviewed the title information, number of different transactions MRC has acquired of the lease interest under this lease. All right, so we have this. Okay. Okay, so now we have this. All right. Ms. Vance, before I turn to Mr. Semenyengo and his response to your motion, is there anything else you want me to know?
Yes. So again, just to make sure that we're on the same page, the summary judgment has made that determination that lease falls under the Dowling family. They are the leasors. And that Matador has the rights to drill under that lease. So Mr. Semenyengo doesn't have the right to tell Matador that they can't go out and drill. They have a lease in place.
But your position, if I'm not mistaken, is that they were not due notice because they don't have a mineral ownership interest.
As far as we can tell, unless something is found different by a different court, as of right now, Mr. Semenyengo does not have that lease. don't want to make any kind of determinations, but as of right now, I can say our position is that we have a lease in place and have the right to drill. Whatever Mr. Samaniego is claiming, that's beyond the scope of this this forum.
Ms. Vance, you're asking me in your motion to request that their entry of appearance and notice of opposition be excluded. So I just said that a moment ago, and you said, no, it's something else. So I'm trying to understand, what relief are you requesting?
We are requesting that he be stricken from the record because he has no interest.
That's what I'm saying.
Yes.
Okay. All right. So now let me look at Mr. Samaniengo's response. So Mr. Samaniengo, Ms. Vance is very simply saying, let's forget about the lease for a minute and anything else. Ms. Vance is saying that the district court in Eddy County has determined through a summary judgment order that you do not own a mineral interest in the west half of this section. And your response is what?
That matter is being appealed, and for anybody, including Mrs. Vance, to make predetermined, premature determinations of who owns what at this point in time is unjust, unethical, it's against standards, it doesn't have standing.
Okay. So now, Mr. Samaniengo, I have a question for you. You mentioned that I've looked through all the documents in this case file and I don't see it. The last document I see here, I have several from today. I have the reply, which I've already denied that motion to strike the applications for MRC Permian or Matador. And I also have your response to the motion to strike. But sir, I don't see any exhibits attached to it. What am I missing?
I submitted. No, they're submitted.
Okay. Miss Chance, am I missing something?
Check the portal. They're in there.
You're not Miss
Yes.
Chance.
There were four separate filings, only in one case, 25247, that were filed under exhibits. And it looks like there are a number of attachments. They may be what I just forwarded you via email.
Oh, you did? Oh, okay. Hold on, because I'm in the imaging system and I don't see them. So let me look at your email. Oh, I have a lot of emails now, so hold on a minute.
They were received within the last hour.
Okay, so they haven't made it to the case file yet.
Right.
All right, very good. Let me look here. Let me look at this document here. Matador invalid. Okay. Mr. Samaniengo, what is this? Let me rotate this so I can read it. Mr. Samaniengo, one of the documents you emailed Ms. Chance is, it looks like a certified mail return to sender. What is this?
That's the invalid fund sent by Matador to invalid, and it was invalid.
You're not helping me understand what this is.
It's an invalid letter of payment. And I want to put this on record. This is how well Matador has done their title work on there. This is how well Chris, the landman, this is how well he's done his title work. Samaniego owned it in the beginning for just a short time. Upon sending termination to Matador, Matador didn't comply for 6 months later, 5 months later, which is well beyond the clauses in the lease.
Mr. Samaniego, I'm asking you a question that I'm not getting an answer to right now. So let me try asking the question a different way to help you. And please, the court reporter has asked that you don't speak over me, because then she won't be able to record what you're saying. And it's important for us to get what you're saying on the record. I'm asking you, why did you file this exhibit? I guess it's an exhibit. It's not marked, so I don't know what really. I don't know if this is exhibit 1, 2, 3, 4, whatever it is. It looks like it's an envelope. I don't see an address on it. It says return to sender, and I don't know how this establishes that you have a mineral interest ownership in this land.
Let me explain how I got it. Okay, Matador tried to pull this area a couple years ago. Whenever they, how can I put it? Whenever Matador was pulling, they sent that stub as a picture in their filings for their application.
Okay,
but,
I understand. Thank you.
That's I'm not really clear exactly what it is for me to make a full determination.
Thank you.
But hold on, I'm not done. Whenever they sent that, Chris, the landman for Matador, he didn't do his job properly.
Okay.
San Diego hasn't owned that. Black Gold hasn't owned that for a while. American owns that, and for everybody to be coming for San Diego owns it, San Diego, like I'm just a mineral owner out there. No,
Thank
American
you,
is an operator, got an agri number.
I'm asking you,
They have well.
If you don't stop talking, I'm going to have to mute you. I'm very serious about this. When I start talking, you need to stop talking instantly. I am trying to figure out what you're sending me here, because I'm trying to figure out whether you have a mineral interest ownership, or at least a colorable argument of a mineral interest ownership or not. Because there is a motion here to strike your entries of appearance, because their evidence is showing me that you do not have a mineral interest ownership in the west half of section 27. Now, I am trying to find something in your exhibits to counterbalance that argument. So now I'm looking at something else you filed, which is a mineral deed. And by the way, Mr. Samaniego, in the future, when you file documents or evidence, you must mark each one clearly with an exhibit sticker so that I can say on the record, I am looking at exhibit A, exhibit 1, whatever it is. And you haven't done that. So I'm trying to help you, but you can't talk over me. Now, you have given me a mineral deed, it looks like. It looks like it was executed on the 14th day of February 2023. What is this deed supposed to tell me, Mr. Samaniego?
Americans' right to purchase an interest, whatever it may be, to develop the lands.
Okay. So, Miss Vance, have you seen this mineral deed yet?
Yes, that's the deed that was at issue in the summary judgment. I would be happy to file a amended exhibit to show the full filing. I only included the summary judgment, but that is the mineral deed in question. So to reiterate, Mr. Samaniego doesn't own an interest here, and we are not seeking to pool him at all.
Now, Ms. Vance, when you say we're not seeking to pool him, that seems like a separate issue. So whether or not you're seeking to pool him, if Mr. Samaniego can establish that he has some sort of a mineral interest ownership in these lands, then he gets to be a party. I've never heard, and unless you provide me with some authority to say that just because you leave someone off of your compulsory pooling list, that they're not allowed to be a party, I've never heard that before. So let's not go there right now.
So just to be, I understand what you're saying,
okay.
But I just want to reiterate, we did not provide Mr. Samaniego any notice because we did not need to. And at this time, because we did not provide him notice, we are not seeking to pool him. I understand that you're saying that that's a separate issue, but it does all tie together.
Well, it may tie together, but the rule is very clear on who gets to be a party and who doesn't. And it doesn't say in the rule that if you're not listed on the compulsory pooling, so that has not, so I'm just.
I understand,
understand
and
what I'm
I
saying?
wasn't trying to I wasn't jumping to that conclusion.
okay.
All I was saying is we are not seeking to pull him regardless of whether he has an interest or not.
Okay. Mr. Samaniego, did you provide the district court this mineral deed?
I believe my attorney handled all that.
Okay, so is that a yes?
My attorney handled all that. I don't want to elaborate. I'm at this time, my attorney handled it all.
Mr. Samaniego, I'm a little troubled by that response. That response sounds to me, first of all, Mr. Samaniego, your attorney.
I don't know. I don't know.
Mr. Samaniego, your attorney is your agent. So whatever you tell him to do, he's going to do it. So did you give your attorney this mineral deed to give to the court?
I believe that the plaintiffs in that matter were the ones that presented that evidence that my attorney went off of to put his response together.
Okay, but your attorney had to get this mineral deed from somewhere, and you're giving it to us today.
Oh, the one that I presented you. No, yes, I got that.
I'm not sure what you mean by I got that. What do you mean by that?
That's the one I filed as an exhibit. The one that's in the complaint in that matter, that was handled by the plaintiffs in that. But the one that I filed today, this morning, that's the one I got from the clerks and I filed. But Mr.
Samaniego, what I'm asking you very specifically, because Ms. Vance is telling me that this mineral deed appears as an exhibit in the summary judgment that the court handed down. So I'm asking you, did you provide this mineral deed to the 5th District Court?
No.
You did not. Did your attorney provide it to the court?
I believe so.
Okay, all right. So then this deed was a part of the court's summary judgment.
I believe so.
Okay. Well, a district court has made a ruling that you are now appealing. I understand that you're appealing that ruling, but for now, what I have is a district court saying that they don't find this mineral deed to convey an interest to you. Okay, so Ms. Vance, is there any, so Ms. Vance, I just want to make very clear, this mineral deed that I'm looking at here that Mr. Samaniego has supplied to us, this is an exhibit in the summary judgment?
It is. Again, I want to just reiterate because
Yes.
I wasn't involved with those cases. Matador doesn't take a position in those cases, other than we know that this is out there. There was summary judgment. It relates to the interest that Mr. Samaniego is claiming. Based off of that, we did not provide him notice. We are not seeking to pull him.
Okay, now Ms. Vance, you don't have to say that again. You said it once already.
I just want to be clear it's on the record. Sorry, Mr. Hearing
You already
Examiner.
said it on the record. I heard it the first time. So let's see here. So Ms. Vance, can you it says here in paragraph 16 of the summary judgment, defendants admitted the relevant facts in their deemed admissions. Defendants American Energy and Black Gold admitted the deeds at issue, exhibits A, E, and F, are void and voidable, A, E, and F. Ms. Vance, did you have the full summary judgment that you can mail me?
I can provide you what my legal assistant pulled from SOPA, which I believe has all of the exhibits attached to it. I can send that right now.
Okay, and would you copy Mr. Samaniego as well?
Sure.
My attorney didn't sign that summary judgment. It's an appeal.
Well, Mr. Samaniego, you're okay.
Can I have time to submit the appeal paperwork? I'm waiting for my attorney to respond. He's probably in court right now with other matters. I mean, no attorney's going to jump on a 10-hour deadline. I mean, I need time.
Of course, and I'll give you time. So why don't you hold on now? So basically, my concern, Mrs. Samaniego, and I think you have this document because Ms. Vance included this summary judgment in her motion to strike. If you look at page 4 of the summary judgment, paragraph 16, I'm particularly focusing on paragraph 16 where they say where it says defendants, meaning you, admitted the relevant facts in their deemed admissions. Defendants American Energy and Black Gold admitted the deeds at issue, exhibits A, E, and F, are void and voidable. Now, I don't know what exhibits A, E, and F are, but if this document you gave me here, this mineral deed, is exhibit A, E, and F of the summary judgment, then I would say that the court has, well, you've already admitted that these are void or voidable.
We never had a hearing over the matter. It was a violation of due process. That's why it's being appealed. No hearing ever took place.
Okay. All right.
American was never served. Parties were never served in this matter. A hearing never took
outside my
place.
jurisdiction, Mr. Samaniego.
You're trying to make a ruling on it as if it were.
Mr. Samaniego,
It's an
your
appeal.
complaints.
Nobody can make a determination for the.
Freya, would you please mute Mr. Samaniego? Mr. Samaniego, you seem to have a problem with not talking over me, and it's really not gonna help you in the long run. So I would strongly caution you to conduct yourself with the proper demeanor and respect of this tribunal. I'm dealing with facts and evidence, and these outbursts that go off on tangents don't help me, and they don't help you. So please just answer my questions, give me what I need, but don't give me more than I need. And please don't speak over me. That's the last time I'm going to ask you this. So, Ms. Vance, you were going to say?
One, I was going to say, Mr. Samaniego, object. It's outside of the scope. Mr. Samaniego bringing up all these issues of appeal. We're not talking about that. But I would point out in the summary judgment, I believe that the court makes clear that Mr. Samaniego and his counsel were given ample opportunity to respond, and they did not.
And what happens in the district court, Mr. Samaniego, is not my concern. My concern is whether you have a mineral interest ownership in this land or if you don't, because that is what allows you to be a party of right to these cases. I am trying to look through what you have provided me, but you have provided me way more than I can look at during this motion hearing, especially, I know you didn't have a lot of time to respond, but it looks like you provided me, I don't know, at least 20 documents to review, and I can't do that at this motion hearing. So here's what I'm going to do. First of all, Ms. Chance, did Mr. Samaniego file this through the portal, or did he just email these?
He filed it in the portal,
Okay.
but only in one case.
I understand. So when I look at, for example, Oh, I see. And a lot of this data is data from our database, purportedly showing that Matador is out of compliance. Okay. So, Mr. Samiengo, what I'm going to do is I'm going to give you a little bit more time. I want to give you the amount of time to refute the evidence that I have in front of me. So what I have in front of me are two documents that matter. They're Exhibit A and Exhibit B, and Ms. Vance has provided you both of them. In Exhibit A, it shows that there is a court of jurisdiction over the ownership matter in the 5th Judicial District that has said you do not have an ownership interest in this land. I will give you an opportunity to provide me with evidence that this is either that even with this summary judgment, you still have an ownership interest in this land. And then we have Exhibit B, which is an oil and gas lease, which looks to me like, again, it says you don't have an interest in this land, and that the interest is owned by Union Oil Company of California by an oil and gas lease of the Dowlings. And the Dowlings were the plaintiffs in the suit against you. So I'm going to give you some more time, Mr. Samaniego. I'm going to give you 2 weeks. I'm going to give you until, today is the 22nd of May. I'm going to give you until June 5th. On June 5th, I want you to file with me a proper response to this motion to strike you. And any exhibits that you submit must be marked appropriately for me to review them. Okay? The only issue here is whether or not you have a mineral interest ownership in this land. That's the only issue. Do not go outside that issue because I won't read it. I am focused on whether or not you are a party in this case, whether you were due notice and whether you had a mineral interest or have a mineral interest ownership in this land. That's all that matters right now. Is there anything more, Ms. Vance?
Not from me, no.
Okay. So, Ms. Vance, I'm expecting from you a proposed order on Mr. Samaniengo's motion to strike your applications, denying that motion. Please circulate it to Mr. Samaniengo before you send it to me. And Mr. Samaniengo, I'm expecting a proper response with proper evidence marked properly to this motion to strike you as a party, because I want to give you the time. I want to be fair with you and give you the time to respond. Do you understand? Ms. Chance, is he unmuted?
I had muted him earlier, but I don't have the ability to unmute him. Oh, he's unmuted now.
And your response, Mr. Samaniengo? Okay, I'm going to take your non-response as a affirmation that you understand. I'm giving you until June 5th to properly file a response with properly marked exhibits supporting your assertion that you own a mineral interest in this land. Okay, we're off the record. Thank you.
Mr. Hearing Examiner? Oh,